Good evening. I'm Beth Ann Gartez, and I'm with Pierce County Coalition for Developmental Disabilities, PC2. It's my pleasure this evening to welcome you to our great opportunity to have information from Tim Williams this evening, who's a previous board member for PC2 and an attorney who's been practicing for, I believe, close to 20 years. Tim will probably correct me. It could be a little bit longer, a little bit shorter, but Tim is an expert in all of the areas. And so tonight, what he's going to be talking about are benefits of special needs trusts and ABLE accounts. And the purpose of this information tonight is to be able to help you be able to plan for future financial needs for your son or daughter. So Tim Williams is our local expert. And so he comes to us with a background from both being a special educator, so he understands individuals who experience developmental disabilities, and then what he's here for us tonight for is his legal background. So Tim, welcome, and we want to thank you so much for being with us this evening. So I'll turn it over to you, and I see the slides are already up. So
great.
Welcome.
All right. Well, good evening, everybody. And I've been doing this more than 25 years now, which is a surprise to me, as I think it is to everybody around me. I've actually been an attorney now longer than I was a teacher, and I just didn't expect that. Anyway, this is the second of three sets of seminars that we'll be doing on successive Wednesdays. Last week, we did general estate planning and what you should be doing in terms of your estate, with a focus on working with families who have somebody with a disability in it. This one is on the benefits of special needs trusts and ABLE accounts. And next week, we're going to be talking about guardianships. This one will probably be just a little bit shorter than last week and shorter than next week. Next week's will probably be the longest just because of the new change in the law. And I'll probably be staying longer for more of the questions next week. In any event, I am Tim Williams. I am an attorney. I have been a special ed teacher. I was a special ed teacher for 23 years with a variety of disabilities. Next slide. Shauna, are you doing the slides?
Yes, I am. I'm so sorry. I hit it too hard. So do I want to go on to the next one?
Next,
Okay.
Next slide. Okay. Eventually.
Yeah, it's not liking me tonight. It's really not liking me. Okay, is that it?
Nope, didn't go. Didn't move.
I have what is a trust up?
And
That's not what I'm seeing.
what we see, Jonna, is benefits of special needs, the initial slide.
Oh, okay. Well, then I need to stop this and start it again. I think it's.
There we go. We have the right slide now.
Is that it? Sorry about that. It paused the share.
Okay. Can you go back a slide? Because I think
Absolutely.
And again, back a slide. There, my disclaimer. Yes, I am an attorney, so I have to have a disclaimer. I make every effort to keep this up to date, but it is not a substitute for having your own attorney talking about individual legal kinds of things. And I cannot guarantee the accuracy of everything here. So that's my legal disclaimer. Next slide. Okay, so we're going to start with our discussion of trusts. Did we skip over a slide? I think we did. Yeah.
Sorry.
Yeah. Yep, there.
Yeah, it's being very persnickety.
There we
Is that the one? Okay.
There we go. All right, we're on track. All right, a trust is a separate legal entity. By that, I mean, we are all individual legal entities. Businesses are legal entities. Nonprofits are legal entities. A trust is a separate legal entity. To be effective, if you're going to have a trust, assets must be titled in the trust name. No, it's not enough just to say that I've got this in the trust. You actually have to title things in the trust. There may be some tax implications to putting things into a trust, and we'll talk some more about that. A trust can be standalone or in a will. We can have just a trust, the Timothy E. Williams Trust. I can put one out there, or the Timothy E. Williams Irrevocable Trust, or Revocable Living Trust, or a Special Needs Trust, all of those things. I can also put a trust in a will or inside of another trust, so that I can put it, if I put a trust in my will, it becomes the testamentary trust. I was just setting up a trust today, a testamentary trust for the benefit of one of the beneficiaries. They can be revocable or irrevocable. Revocable just means I can change it at will. Irrevocable means that I cannot revoke it. It does not necessarily mean that I can't change it in some specific ways. And so it's very important that all these trusts are different, that you take a look at the individual language in the trust. Next slide. Back one more. There we go. All trusts have three elements. There is a grantor or settlor. There is some technical differences between the two, but generally they mean the same thing. A trustee and a beneficiary. The grantor is the one who sets it up and typically funds the trust. A trustee is the one who manages the trust. A beneficiary is the one who benefits from the trust. You can be all three in some trusts, but not in all trusts. In a special needs trust, the beneficiary cannot be the trustee. The beneficiary could be the grantor, but can't be all three in a special needs trust. Next slide. A word about being a fiduciary. Fiduciary is a big legal term, and I find many of my clients, maybe even most of my clients, are not familiar with that term. It is a legal term. That means that you may not act in any manner that is adverse or contrary to the interests of the principal, the beneficiary, nor may you act for your own benefit in relation to anything going on with the trust. What does that mean? It means that you can't borrow the money from the trust if you're the trustee. It means that if the trust is trying to sell something, you have to be very careful before you buy it. Sometimes a trust has a car or a house or something, and you might want to do that. Generally, the trustee should not be doing that. A fiduciary must exercise all of the skill, care, and diligence at their disposal. So as an attorney, when I act as a fiduciary, I have a higher standard than somebody who is not trained to do these things. A fiduciary is required to make truthful and complete disclosures to the beneficiary. You can't hide things. You can't not say something about the trust to the beneficiary just because you're unhappy with something. You'll always have to act in the best interests of the beneficiary. I can do a seminar for 8 hours on what it means to be a fiduciary. It's a very long and complex subject. And if you're interested more in what you're doing, or if you are a trustee or are otherwise a fiduciary, I have a lot of information on my website. Next slide. So a special needs trust is a specific kind of trust. And for our purposes, a special needs trust is there to protect SSI benefits, Medicaid, or other needs-based income or assets. In order to qualify as a special needs trust and to protect those benefits, it must be for the sole benefit of the disabled person. What does that mean? Means only one person can be the beneficiary. I have clients who have 3, 4 disabled people in their household. I can't have one trust for all of them. I have to have separate trusts for each of them if it's going to qualify for this benefit. It always has to be supplemental, not a basic support trust. That means that it can't be required to provide regular living expenses. A beneficiary cannot compel distribution. The beneficiary sometimes thinks that it's their money. It isn't their money. It can only be used for them, but it's not their money. And they can't say, gee, I want this, I want that, and expect the trustee to always comply with that. The distributions must be discretionary with the trustee. Again, these are all requirements of a special needs trust. Next slide. It's considered an exempt asset under SSI and Medicaid rules. SSI and Medicaid both require that the individual who is getting Medicaid or SSI, and this is traditional Medicaid, have no more than $2,000 in assets. That's not very much money. And in fact, that limit has been there for a long time, decades. There are some things that are exempt from that $2,000 limit. The biggest one is a house. You can have a house, it doesn't count. You can have a car and it doesn't count. But, and you can have a special needs trust if it's appropriately drafted. But that's it. You can't have $2,000 or more in the bank. Note that Section 8 housing treats special needs trusts a little bit differently. And even a special needs trust can have a negative effect on some subsidized housing. Next slide. So we're going to divide our special needs trust into 2 basic kinds. One is called a first party or self-settled special needs trust. The other is a third party trust. So we're going to start by talking about the first party trust. Funded by assets that legally belong to the beneficiary. Where did the beneficiary get this money? Perhaps it was an inheritance, not directed specifically to a trust. Might be from a personal injury settlement. Got in a traffic accident and had an injury, and the insurance company paid off for their pain and suffering. Could have been a gift from anybody. Could be from work. Could be gambling proceeds. We actually had a case out of PC2 where somebody was playing the slot machines and they got a jackpot, $75,000. They're on SSI and Medicaid. Guess what? That is income for SSI and Medicaid, and it has to be reported. And so all of a sudden, they no longer qualified for SSI and Medicaid because they had more than that $2,000 limit. And so we can put that into a first party or self-settled special needs trust. Next slide. It is covered under federal law by 42 USC 1396 D4A or D4C pooled trust. And I put this in there because these are often abbreviated as a D4A or a D4C trust. So if you hear that terminology, that's telling you that it is a trust that at least is expected to be qualified as a special needs trust under US and Washington law. It must have a Medicaid payback provision. So any Medicaid assets that have been used for the benefit of the beneficiary When that beneficiary dies, the trust has to have a provision in it that says we get first crack at whatever money is left. That's not true for the SSI. SSI doesn't want their money back unless they've been overpaid. So you don't have to worry about it for that. But sometimes the Medicaid payback can be many hundreds of thousands of dollars for somebody who's been on Medicaid for a long time. The specific requirements of this D4A trust is that it must be established by the person themselves, or a parent, or a grandparent, or a guardian, or the court. Note that siblings aren't on that list. Children are not on that list. You have to be aware that there are some significant restrictions. Potentially, you could use a power of attorney to implement a special needs trust for somebody, but sometimes that can create problems. So you need to get good advice and make sure that you're doing it correctly. Next slide. First party self-settled trust is also known as a grantor trust. Now, there are many other kinds of grantor trusts out there, but a special needs trust, D4A trust, is a grantor trust. You don't have to get a tax ID for it, but it may be good to get one anyway. If you're not familiar with tax IDs, trusts and businesses that have separate tax requirements need to get a tax ID. It's sort of the entity substitute for a social security number. In order for it to be a D4A trust, you must be under the age of 65 to set it up. Not sure why that requirement is there, but it's there. That is not a requirement to set up a D4C trust. Next slide. There's no separate income tax for a grantor trust. You have to file a separate income tax return for some other kinds of trusts, and we'll talk about that. But all income is taxed on the beneficiary's income tax. Let me give you a specific example. Let us imagine that you have taken $100,000 from whatever source, got an inheritance or played the slot machines, played the lottery. Would have been nice to win that $1 billion lottery, right? Put it into a special needs trust and you put it into an investment account or some CDs. And so it's earning some money. Maybe it earns 5%. So it's earned $5,000 over the year. That money has to be taxed someplace, whether it's distributed or not. And that's going to be taxed on the beneficiary's income tax. Now, if the beneficiary is on SSI, they don't have to file an income tax return. I recommend to my clients on SSI that it's probably a good idea to file a tax return, but it's not required. But now, all of a sudden, they have $5,000 in income. Not going to affect their SSI, but it does mean they're going to have to file a tax return. So you need to be aware of that. Next slide. There we go. There is also what's known as a D4C pooled trust. When the person dies, instead of going to Medicaid for a payback, there's a provision that it can go back into the pool. So if you are in a pooled trust, your trust can be added to by some of the people that have died that are also in that pooled trust. Next slide. There are a limited number of pooled trusts in Washington. There's an endowment trust run by the Arc of Washington. You must be a client of DDA in order to benefit from that. Lifetime Advocacy Plus in Seattle is a large company that it's a nonprofit that manages and has a pooled trust, a D4C trust. And Beagle and Associates down in Vancouver is a private company that runs some pool trusts. There are also some out-of-state pool trusts, so you're not limited to just these, but there aren't many out there. Most people are not real aware of them. It's still looking at a D4C pool trust. Next slide. So now let's see. Let me see if there's anybody that has a question about what we've talked about so far. That's a good time to do that. I've got one thing in the chat that I will let somebody else take care of. Anybody have any questions? I'm not seeing anybody else's thing, so I can't tell if anybody is raising their hand. Let me see if I can do side by side.
Rachel has her hand up, Tim.
Okay, there we go. I was able to change my screen here so that I could see that now. Rachel, you have a question?
I do. On this first party trust, a couple of questions. From your first slide on it, inheritance is not directed to the special needs trust. Is that saying that if the beneficiary receives an inheritance directly in their name, then there's still time to create the trust and put it in without having there be ramifications to other benefits? Or does it have to be already in place and the inheritance before the inheritance is?
I think that will become your question. The answer to your question will become a little bit clearer once we start talking about the third party trust. But a first party trust, because it has that Medicaid payback provision, is maybe not the best place that you want to put it. But if they got that money from an inheritance, and yes, it was just directed to them, wasn't directed to a trust for their benefit, we can in fact turn it in. We can set up, and I do that often actually, so that they can benefit from the special needs trust rules. As we'll find out here in a moment, a third party trust can sometimes be a better option for you to if the money has been directed there initially.
Okay.
Okay.
Okay, and then on the third party trust, in the discussion about the income, I wrote down all income is taxed on the beneficiary's income tax return.
On the first party trust, yes.
That was still first party? Okay. I didn't notice when we switched to third party. So, and you said it doesn't affect SSI. Does it affect Social Security? Is it considered earned income for Social Security or unearned income? The income from the principal.
Okay, so that's a good question, and let me share some things with everybody on that, because you're talking about. I have many clients who are on SSI, which is automatically reduced when you get any money. There are some special exceptions for people under 25 who are working. It doesn't get reduced quite as much, but it still can get reduced. But there's also, I have a lot of clients who are no longer on SSI who are receiving Social Security disability, either on their own account because they had some work history, or as an adult disabled child because they have a parent who is on Social Security.
Right.
Social Security, if you're on Social Security, they don't care what your income is. I'm on Social Security. Social Security doesn't care what my income is, whether it's earned or unearned. They don't care. Not going to affect my benefits in any way, shape, or form. I have a right to that benefit regardless of my other income. And quite frankly, regardless of my other assets. So we don't need a trust for that. Typically, the trust is still needed for Medicaid services if somebody is on Social Security disability. Also needed for management purposes. And so we use the trust for all of that. Does that make sense?
It does. I guess my understanding was otherwise, in that my daughter had the Social Security begin as a minor because of the loss of her father. And then she just switched to 18. So now if her classification is disabled adult child, that doesn't matter anymore. And she can earn and work and it won't affect her Social Security.
That is correct to a certain limit. So let me add really quickly one caveat on that. So long as she remains disabled,
Mhm.
then she can earn and it won't affect it.
Okay.
Your disability is based on your ability to earn. And so if you can consistently earn, and I don't know what the limit is right now, I think it's around $1,200 a month.
I think it's
You can-
1,700 now, but I could be
What?
wrong. I think it's closer to 1,700 now.
Woo!
Yeah, big difference.
It was down below 1,000 for a long time. In any event, if you can earn a living wage, then all of a sudden you may no longer be disabled and all of your disability benefits are going to go away. And I've had a number of clients who have good jobs, but they still need a job coach and they still have other issues. They're still disabled. And so if you're not careful about how much that person is earning as an adult disabled child, or as anybody who is collecting disability benefits, you can lose those disability benefits. And it can be, it's number one, it's stressful and it can be very difficult to get them back. Most of my clients who've been in that situation have ultimately been able to get that benefit back. So it's not an unlimited amount of money that you can earn, but yes, it's not like SSI where your SSI is reduced by the amount of money you earn. You
Okay.
get to keep the money.
So, but if the income is generated from the investment specifically, so the person isn't working, so they still have the qualifying disability to prevent earning a great wage.
That-
but isn't
That's
it-
right. In that sense, now I'm beginning to understand your question a little bit better. Unearned income is never going to affect it.
Okay.
So,
Great.
so a third party special needs trust.
Tim, we have a couple other questions in the chat.
Oh, okay.
Thank you, Tim.
Let me take a look here. Can we include asset abroad to the trust? I'll give you the standard attorney answer for any question you would ever ask an attorney. It depends. And a lot of that is going to depend on the country that the asset is in. That's real specific, and you need to be careful with those. And how long before the death of the beneficiary do we have to change a trust to a pooled trust? Okay, I'm not sure I understand that question.
Hi, Tim, it's Marilise. For instance, a property like a house can still be taken away if Medicaid, this is just with adults, if they need to go into a nursing home or so on, or with dementia. And so I'm wondering about the same problem, whether if I would like to rather change my child's income or the disabled person's trust to like the pooled, where it benefits other disabled people, but I know Medicaid has a 5-year rule, for instance, that you would have needed to change your income and your assets, because they could go back and go look for the money.
And while all of these rules are applicable to the elderly disabled who become disabled, as well as to the developmentally disabled or people who have long-term disabilities, I'm primarily focused on the developmentally disabled. The biggest problem with the pool trust, if I've got your question correct, is that the pool trust isn't going to be able to hold on to a house. A pool trust is not going to be able to have an asset other than money. Whereas a special needs trust can hold property and houses and that sort of thing. There's, in a first party trust, there's always going to be a Medicaid payback. So just like with your elderly person and dealing with the house, there may be an estate recovery on a first party trust if you put a house in there.
Okay, and other assets, so I could change, say for instance, we realize that our child has 6 months left or something like that. I could still then go and change it over to a pooled trust, and without Medicaid going into a review of past income and assets.
I think so. Your question is getting real specific, and so maybe we should talk separately about that.
Okay, thank you.
Okay, so third-party special needs trust funded by assets that never belong to the beneficiary, commonly in a will or can be a separate standalone trust. The grantor, that's the person who is funding this, can select the trustee and the ultimate beneficiaries. There are tax implications because the trust tax rates are higher. Okay, next slide. Must have a tax ID and must file taxes to the extent that it has income. And so that's done on what's known as a 1041 and a trust income tax return. If the beneficiary has a qualified disability, it's considered a qualified disability trust. And so the rates are not quite as bad as they are for other trusts. Distributions of income are taxed on the beneficiary's tax return, just like in a first party trust. This requires some coordination with the beneficiary. Let me give you an example of what I mean there. Let's go back to our example. I've got a trust. Initially, I had a first party trust with $100,000. It made $5,000. That, regardless of what you did with the $5,000, whether you distributed for the benefit of the beneficiary or just held on to it, somebody has to pay tax on it, and it's going to be the beneficiary. It goes on the beneficiary's 1040 tax return. In a third-party trust, now we have to know what you did with that $5,000 of income. If you distributed it, then it's going to go on the beneficiary's tax return, and they'll have to pay taxes on it. The trust obviously should be paying those taxes. You don't expect the beneficiary to do that, and it's not going to affect their benefits regardless of what you do. But if you distributed that full $5,000, then they're going to pay tax on the beneficiary's tax return. But if you remember from the very beginning, the special needs trust must be discretionary, and the trustee has the ability, the power to say, I'm not going to distribute anything this year. It makes $5,000 and nothing gets distributed, nothing for the benefit of the beneficiary. Then the trust is going to have to pay taxes on that $5,000 and file the 1041. And so there'll be a tax, and that tax will probably be higher than if you had distributed it. May not be enough higher to make it super beneficial to do that, but that you need to be aware of that, that's out there. If you distributed part of it, say $2,000, then that $2,000 would be taxed on the beneficiary's tax return, and the $3,000 left over is taxed by the trust on a 1041. Next slide. So, anybody have any questions about the third-party trust before we dig into achieving a better life experience? Seeing no hands. All right, so ABLE accounts, achieving a better life experience. This is a disability version of 529 plans. Many of you are familiar with 529 plans. If you're not, it's a way for people to put money away that they have earned and not pay taxes on it. It was designed so that I could put money away for my children or grandchildren for college and have it grow without paying any taxes on it. And then under many circumstances, I get a better tax benefit even when the money comes out. The reason that we have an ABLE account is because the parents of a whole lot of disabled people with disabilities lobbied their congressman and said, our kids aren't going to college and we should still have the benefit of a 529 plan. And so they started Achieving a Better Life experience. It was made available about 2014. Washington was a little late coming to it. They are run by the states. Next slide. This is where I have it. I think I get into a little bit more ABLE counts in a minute. So why is ABLE important? An individual who receives SSI or Medicaid is obligated to report to DSHS by the 10th of the following month any money received from any source. We talked about gifts. We talked about earnings. We talked about winnings, lottery winnings. Any number of things can happen. Inheritances that weren't directed. SSI and Medicaid can and often be reduced. There's a disincentive to save. Next slide. So an ABLE account, anything you put into an ABLE account will be disregarded for Medicaid and SSI purposes. With a few exceptions, no other source of income is exempt from being counted for SSI or Medicaid. They look at virtually everything else. This is a really big deal. If you're not familiar with ABLE accounts, especially if you've been working with somebody who is on SSI and Medicaid. Next slide. Savings can be very important to many. This is a real, has been a real disincentive to save. I can't have more than $2,000. It's very restrictive. A special needs trust can be expensive and burdensome for small amounts, and the source of the contributions is irrelevant. Next slide. Washington Stable, which is what it's the state ABLE account. Washington State ABLE account is known as the Stable account. It is available for Washington residents. 49 states and the District of Columbia have active ABLE accounts available. Every state is different. There are a couple of states that have 2 or 3 different plans. Some states allow out-of-state residents to work with their ABLE account. And before Washington was set up, I was directing people to Pennsylvania and Alaska and North Dakota to get their ABLE accounts. Every state is different. Washington may not be the best state for you. Most of my Washington clients are very happy with the Washington Stable account. Next slide. In order to qualify for an ABLE account, you must be disabled. If you are receiving SSI or SSDI or adult disabled child benefits, you are categorically disabled. That is, we already know you're disabled because somebody else has determined that you are in that category. But not all of my clients who are disabled are receiving SSI or SSDI or adult disabled child benefits. And there are still some benefits to the Medicaid rules. Not everybody who is on Medicaid is categorically disabled. So if you're just on Medicaid and not on other disability benefits, you must have something that says that you are disabled. You don't have to provide that when you're filling out the application, but they say it must be available. Why would you be in that situation? Well, I have many clients whose disability only manifests itself in their late teens or early 20s, and they may not have gone through the whole process of becoming officially disabled yet. Next slide. A disability must have been present prior to age 26 and has or will last longer than 1 year. There is been some interest in raising that age to 45, I think, but at present it's still age 26. This does not mean that disability benefits must have started prior to age 26. I have many clients who are relatively mildly disabled, but it was discovered in their early 20s that, gee, we thought they were going to be able to work, but maybe not. Maybe they have autism, or maybe they have some other low intellectual functioning that's creating a problem, or a mental illness that just manifested itself late in their teens or early in their 20s. And we haven't gone through the process of being legally disabled. If you've got some evidence that the disability started before age 26, that's good enough. Head injury is a big example. If I got a head injury at 25, had an accident at 25, I may not be able to get disability benefits for many years after that. But it's clear, because that was an event, that it started prior to the age of 26. Next slide. It may be set up by the individual with the disability, or by an authorized legal representative, such as a guardian or attorney. In fact, when you apply for it, and the individual is not the one applying for it, or is unable to apply for it, you have to say you have legal authorization. I have a number of clients who do not have guardianship for their very disabled children who could not do this for themselves in any way, and could not sign a power of attorney. But the fact that they don't have guardianship should not be a barrier to setting up an ABLE account. And I have had many of my parents do that. That authority comes from both the common law and from the informed consent statute, RCW 7.70.065. Next slide. An ABLE account must be used for a qualified disability expense. The statute says, what is that? Any expense related to the designated beneficiary's blindness or disability that assists him or her in increasing and or maintaining their health, independence, or quality of life. Next slide. These may include expenses related to education, housing, transportation, employment, training and support, healthcare expenses. Lots of different things can be included in that. Next slide. This is very broad. Congress, in its wisdom, was very kind to us. And I make the argument that almost anything used by an individual who is disabled on SSI or Medicaid is related to the disability, is at a minimum, it is increasing their quality of life. Nevertheless, you should think about this when distributing, just because it's there. And I'm going to mention this again when we talk about the differences between ABLE and special needs trust. A special needs trust does not need to be used for the person's disability. as long as it's used for the benefit of the individual, it's fine. An ABLE account must be used for the disability. I think that's a subtle distinction. I think in practice, it's not much of a distinction, but it's there in the law and you need to be aware of it. Next slide. The Department of Treasury, which is an odd agency to be doing this, is responsible for ensuring that the funds in an ABLE account are being used appropriately. They may do this by conducting periodic audits, but there is no report of their having done so. As far as I can tell, the Department of the Treasury, Federal Department of the Treasury, has not audited anybody's ABLE account for any reason. Next slide. The statutory penalty, if you misuse an ABLE account, is the loss of the tax benefit. Income from an ABLE account, interest, dividends, is tax-free. You don't need to worry about a tax return for the ABLE account. Next slide. While it is possible that failure to use the funds for a qualified disability expense will result in the funds no longer being exempt, at present, there's no agency and no mechanism for doing that. Next slide. I'm just going to go over that briefly. Common characteristics of an ABLE account. First of all, it's tied to the gift tax amount. In 2021, that amount was $15,000. So when we started ABLE accounts, it was limited to 15,000. This year, that went up to 16,000 just for the year 2022, and it's going up to 17,000 in 2023. So that's the limit that you can put into it in any given calendar year. There are some exceptions to that for people who are working. So you can, if you've got an ABLE account set up for a disabled child, for example, who is also working, they can put some of their money into that as essentially a savings account. And there are some exceptions to the $17,000. The ABLE account people will let you know how much you can do, and they'll give you a direction on that. Each person can have only one ABLE account. The asset grows tax-free. One of the things that you're going to be doing when you sign up for an ABLE account is asking whether or not how you want the account invested. Do you want it in conservative investments or medium investments or aggressive investments? I wouldn't spend too much time worrying about that. We're not talking about a lot of money. $15,000, $16,000, $17,000 a year is not going to earn a whole lot of money, even in an aggressive investment. It is not an entity like a special needs trust, so it cannot hold physical assets such as a house or car. Next slide. I've had a lot of people tell me that you can't put more than $100,000 into an ABLE account. And I am not sure that varies from state to state. I don't think Washington has that limit, but it may. But if you are on SSI and you get more than $100,000 in an ABLE account, by law, SSI is suspended. You still qualify it, but it's going to go away. So you need to be aware of that because you probably don't want to suspend the SSI. So you don't want to put that much money into an ABLE account. Again, the disability must have occurred prior to the 26th birthday. This almost looks like a repeat of one. If they meet the onset requirements, are clearly eligible. Others who have significant disabilities, even though they may not be on benefits, can also be eligible. Next slide. It's easier and less expensive to open and use than a trust. Okay? If any one of you wanted to you could probably open up an ABLE account this evening before you went to bed. It's that simple. Online application, just easy to do. It provides some tax benefits. It goes tax-free. Does not have to worry about whatever income it makes. The person with the disability can have control over the account. If they've set it up themselves, they can have complete control. Or if you're setting it up for them, at least in Washington and most, I don't know about all other states, but most other states, you can have it set up so that it can be tied to a debit card. And you can have some control over that debit card. You can restrict the amount of money. You might have $10,000 into an ABLE account, but you can say, I want this debit card to only be able to use $100 a month or something more, something less. You can also restrict to where it's going to be used. I don't want it to be used at the casino. I don't want it to be used at the pot shop down the street. So you can put those kinds of restrictions on it. Next slide. It can be a much more normalizing experience for the beneficiary. They can buy their own stuff. Before we had ABLE accounts, and I had people who had special needs trusts, somebody wanted to go buy some clothing or something else for themselves, maybe a TV or some furniture. Well, it's not a good idea to give the person money if they're on SSI. And so they had to go select what they wanted. And then had the person who was the trustee had to go buy it. With an ABLE account, you can actually put the money in the ABLE account and they can go buy their own stuff. That's not appropriate for all my clients, but it is appropriate for many. It can also be used for housing expenses. You may or may not be aware that if you're on SSI, if you don't have to pay for your own room and board, your SSI can be reduced by up to a third. I have a number of clients who are not aware of that. They don't charge, they didn't initially at least charge their disabled child room and board. And so they were getting a significant amount less in SSI. If you're charging for room and board, then you get the full amount of the SSI. Money from an ABLE account can be used to improve the amount that they can pay for housing if they're in independent housing. Next slide. Some advantages to special needs trust. Rachel, I will get to your question in a minute. Has no limits on contributions. I have some clients who have $1 million special needs trust. It does not require that the disability begin before you turn 26. Now, for most of my clients, they are developmentally disabled and their disability started very early, if not prior to birth. But there are a number of people who get disabilities after that through injury or other mental health issues. And so a special needs trust is still available to them. A third-party trust has no Medicaid payback. Some states have stated that they will not do an estate recovery for an ABLE account. My understanding is that Washington is going to do a state recovery for an ABLE account. And I am aware, because I've had a couple of clients who have died within the last couple of years and did have ABLE accounts, Washington does want that money. So if there's any money left in the ABLE account, the person was on Medicaid, received Medicaid services, typically either out-of-home care or personal care hours, the state is going to come and say, what's left in that ABLE account is ours. Next slide. The money in a special needs trust does not have to be spent on qualified disability expenses. I've mentioned that. There's no maximum amount. It can hold on to vehicles and real property. That is a significant advantage that I have many clients who have put houses into vehicles or houses into special needs trust or vehicles into a special needs trust so that it can be managed properly and is particularly for a third-party special needs trust, no estate recovery. You get oversight by a trustee who must approve disbursements. That may be an advantage, that may be a disadvantage for some of you. Next slide. So many people can benefit from having both an ABLE account and a special needs trust. And I have many clients who do have both an ABLE account and a special needs trust. I have a number of clients who have multiple special needs trusts in addition to an ABLE account. It can be a significant increase in quality of life for those who can manage some money, and it can allow for savings that were not previously allowed. It really is a huge thing to have. Next slide. I think I'm almost done here. Oh, that was the last slide. So we have a question from, let me pull up my chat. Chat. Okay. How much to charge for room and board? So if you're in the situation of doing that, SSI is presently what, about $850 a month? Somebody?
It's 800, it's a little higher than that, but 879 or something like that.
I because I don't do that all the time, I don't keep track of that. Most of my clients charge in the neighborhood of $500, $600 for room and board. In a typical middle-class household, I think that's reasonable. Probably nobody is going to question that. I have not raised my recommendations. I've been telling people $400 to $600 for years as the SSI has gone up from, at least when I started doing this, it was about $550. And it's now up over in the high 800s. So you can probably reasonably charge $600 or $700 for room and board. And you probably should be. I'm not going to mention much more than that about room and board. If you have specific questions about that, I know Beth Ann and other people at PC2 have some input on that, and you're welcome to call me and I'll give you some ideas about that. Next question from Do Jin, and so I guess this is going to get interpreted. How can we clarify when the money in the account is used for the disabled? Where can I make an account for loved one? Any bank? Can I deposit the money for the disabled? Are there no limits of money or deposit? In your question, you have not specified whether we're talking about an ABLE account or a special needs trust. And they are treated very differently. So I'm going to answer your question. It's a good question. I'm going to answer your question in really two ways. One is, if it's an ABLE account, you have to set it up with the state and they will tell you where to send the money. It's not held at a bank. Don't just Google ABLE accounts, by the way, because there are financial institutions out there that are actively soliciting people for it without making it clear that it has to be run by the state. And I believe that there are also some scammers out there. So go to the Washington Stable account, or, and I think I've put this in my materials, to the ABLE National Resource Center. And take a look at what states are doing. If you have a special needs trust, and you're the trustee of the trust. So you will have to have a trust document, and you will have to have it set up as a trust. Then you will also have a tax ID, and you can go to any bank and you can set up the trust. But once you have done that, now you can put the money into it. Most banks will take a special needs trust. Some credit unions will take a special needs trust, but some will not. So you need to be careful about where you go. Does that answer Do-Jin's question? Oh, Jin So, you've been interpreting that.
So Tim, what happens when you have some property in Korea as a source of income?
That's a good question. So nobody has asked me that before. So if I had a rental in Korea or any other country, and that money was coming to me, a disabled person in the US, it's going to be treated no differently than income that I get from something here. Now, potentially there's a problem. If I'm a disabled person, owning property in Korea probably disqualifies me for Medicaid and SSI because it over assets me. So it's a bit unclear to me if I have property that is a source of income. If I have a relative that's a source of income in Korea or any other country, somebody, it's not my money, it's their money, and they want to send it to me, that's treated differently. And for that, an ABLE account or a special needs trust works very well.
So Tim, what we could do at this point is we could, thank you very much for doing this, and we could stop our recording, and then we can go to people being able to ask their individual questions. So
Okay.
unless we have any more generic questions, what we'll do now is say thank you to you very much for all of this great information, but we're not, and then we will be discontinuing the recording. So if you ask a question now, then it will be recorded. If you wait until we just stop the recording, then it will be individual to you. All right. So, Jonna, if you'd like, we'll go ahead and stop the recording. Thank you very much, Tim.